It's probably the most extreme example of litigation that is impactful, litigation that demands accountability. 24 years later, we're still uncovering the connections between the Kingdom of Saudi Arabia and these attacks, how they were sponsored, how they were supported, how they were carried out. There's a lot of similarity between how the social media industry handles its issues and the way the tobacco industry handled it for 50 years before that litigation came. Our ability to hold companies more accountable today isn't because companies are behaving different necessarily. It's because we're able to call them out using their own documents in a way that's much more advanced, much more sophisticated. Those are the types of changes, quite honestly, that companies like Meta are more worried about than getting a $375 million verdict like we did. They can pay $375 million. They can make that money in a month. My family is my world. And I can tell you that they missed a lot of me over time because of this job.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a trial lawyer who has spent his career at the epicenter of America's most historic litigations. From the landmark big tobacco lawsuits to groundbreaking cases aimed at bankrupting the financiers of the 9/11 attacks, he consistently uses the civil justice system to hold powerful entities accountable. A member at Motley Rice, he has served as co-lead counsel in massive multi-district litigations against giants such as Johnson & Johnson and C.R. Bard over defective hernia and pelvic mesh. Today, his docket ranges from the National Prescription Opiate MDL to leading a historic trial to hold Meta accountable for the harm social media inflicts on children. And we'll be sure to talk about all of those. It's my pleasure to welcome one of the nation's premier mass tort attorneys, Don Migliori, to the podcast. Welcome, Don, and thank you for being here.
Thank you for having me. I'm happy to be here.
Yeah, it's my pleasure, Don. So as you know, Don, I like to start by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
Maybe it's a little bit of both. My story is a little bit different. I'm the last of 5 boys. I have 4 brothers, and they're all surgeons. So you can imagine that our Thanksgiving dinners, a lot of lawyer jokes. So I thought a lot about those lawyer jokes, and my dad, who was also a doctor, but an anesthesiologist, he said, I've got something for you to neutralize your brothers. And so he told me a joke that I could fight back with them on. And so he said, next time they give you a hard time, ask them what's the difference between God and a surgeon. And so I did. I brought that up at Thanksgiving, and my brothers, of course, didn't know. And I said, well, God never thought he was a surgeon.
That's awesome.
That's my little fun fact. But you'll hear through most of my interest in law really comes out of my family history in medicine. And so most of what I do has a strong slant towards the medical side and public health.
That makes so much sense. Yeah, given some of the things that we'll no doubt get into. So actually, that's a perfect segue into my next question, which I love to ask every guest, which is that I consider every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story. And you just shared a little glimpse of yours there, but can you share a little bit more?
Sure. So, like I said, I'm the last of 5 boys, and we all were very involved with public health and community-based issues. Even as little kids, we were always very much involved in our communities. And so my approach to law came initially, I worked on the defense side. And what I found on the defense side was I really learned skills in practicing law, but I wasn't doing it with passion. Saving companies money or proving somebody to be telling the truth or not telling the truth didn't have a passion for me. And so I defended asbestos companies initially, and met some folks on the other side at a firm called Motley, our predecessor law firm, who were doing the plaintiff side of work. And it really felt like they were trying to do something more than just make money. They were trying to do something to cause real change. And the asbestos litigation is where I started. And so my origin story really was about trying to understand how to use the civil justice system in a way that did more than just compensate, but really created accountability, change, and really gave voice to folks who were injured in a way that they couldn't on their own against major corporations. So it started out of a real interest in trying to do something meaningful and impactful, and seeing, unfortunately, at the beginning on the defense side, that the folks that were doing things that were most impactful and had the most public health implication were folks doing the kind of work that I now do in the mass tort side of work.
That's fascinating. And so it's interesting, right? I mean, until we just got on air here, I did not know about your family's history and association and the strong links that they have to the medical profession. And that makes so much sense with regards to how you focus your work in that area as well. Let's go back maybe 25 years or so. So you served as liaison counsel for families of 9/11 victims who opted out of the victim compensation fund because they wanted answers of accountability versus a guaranteed payout, right? And you helped lead the MDL designed to bankrupt the financiers of Al Qaeda. So can you tell the audience a little bit about what that victim compensation fund was about? Who were the victims who opted out? Why did they opt out? And then what happened through as you led those victims through the process?
Sure. And I actually taught a course on this in a law school in Rhode Island called Roger Williams. It's fascinating. So the 9/11, of course, was historic, nothing like it in history, not just in terms of politics and international diplomacy, but in terms of law. We never had a moment where our entire aviation industry was shut down by something so catastrophic as an attack on the country. And in that process, Congress, within 11 days of 9/11, passed a law that basically created a no-fault victims compensation fund for the folks that died or were injured on September 11th. The reason they did that is because they wanted to stabilize the aviation industry. They didn't want the impact of this terrorist attack to shut down the aviation industry in such a way that it would actually cause all the airlines to go bankrupt. So it's called the Stabilization Act. It was really designed to protect the aviation industry and give compensation to families who are so impacted, but taking away accountability from the formula, right? They did it in a no-fault system. Most of the families of the 3,000 or so deaths, all but about 100 of them chose to go into the Victims' Compensation Fund, as opposed to suing the airline industry and the security companies that were around on September 11th for accountability. The 100 claims that went forward against the airline industry and the security companies and opting out of the Victims' Compensation Fund, they were in an MDL in New York, and I was co-lead trial counsel for those victims. So the first litigation outside of the Victims Fund was this aviation security litigation, and we prosecuted those 100 claims on behalf of those families that chose not to go into the no-fault fund against the airlines. And that recovered a significant amount of money for those families. But more importantly, it uncovered a lot of information about the security failures that day. The security failures at the checkpoints, the security failures of the airlines themselves. And so that is really the opt-out issue. It was between aviation security or the Victims' Compensation Fund. But whether or not you chose the Victims' Compensation Fund or the aviation security litigation that I co-led, everybody could sue the sponsors of terrorism. And so now we have pending, still in the courts, 24 years later, we still have in the courts a litigation against those that provided material support to Al Qaeda in carrying out the 9/11 attacks. And that's based on a law that was passed after, if you remember, the Lockerbie terrorist attacks that killed 31 students from my alma mater, where I went to law school, from Syracuse, who were studying abroad. Those attacks led to the creation of an Anti-Terrorism Act that was passed ultimately and amended in 1996, which served the basis of this national terrorism litigation that I'm also co-lead counsel of. That litigation is still going forward. The Kingdom of Saudi Arabia is still a defendant. We've had some major rulings in the past year, but it's probably the most extreme example of litigation that is impactful, litigation that demands accountability. 24 years later, we're still uncovering the connections between the Kingdom of Saudi Arabia and these attacks, how they were sponsored, how they were supported, how they were carried out. And it's not just the Kingdom of Saudi Arabia. There are banks, charities, businesses that provided support to the 19 hijackers that day and getting them on the planes and getting them in situations or positions to carry out the attacks that they did. So it's probably the biggest litigation I've been involved with over the 40 years I've been practicing, and certainly the most international, the most complicated in terms of involving diplomacy. But it gets back to the very same premise. It's giving voice to individuals who are harmed by demanding accountability, answers, compensation, and ultimately change. The biggest change that came out of 9/11, of course, was that we no longer put security in the hands of private companies like we did on September 11th. Now it's in the hands of the TSA. And good or bad or indifferent kind of security, it's a different awareness of passengers traveling on planes today. And a lot of that comes from litigation that produces answers about what kind of weapons were on board that day, how they got through the security checkpoints. And with respect to terrorism, just how terrorist groups get funded and supported to carry out these horrific acts. So it's the biggest litigation. Hopefully, we will get it resolved before I retire in 20 or 30 years from now, maybe.
That's amazing. Thank you for walking us through that, Don, because I can imagine the complexity of everything involved. Obviously, there's this massive national tragedy, and each individual family has their own, personal tragedies to deal with. But on top of that, it's not just normal quote unquote litigation. There's overseas players. It's international. There's geopolitics. There's politics. There's national security. All of those elements coming together. But if the end result is that there's at least more awareness of these threats and sort of different measures, hopefully better measures to counteract these threats, then that is a win for all of us. So thank you for the work that you did there.
Yeah, no, absolutely. In fact, let me just say one thing. That one of the strongest concerns that I have as a person who cares about the system is that people don't lose sight of the fact that our system works. Even in an extreme situation like 9/11, which has so many dynamics to it, so many complications to it, so many different influences upon it. Our civil justice system works. It has a capacity to take on very serious problems like this, and through good judges and good lawyering, bring issues to the forefront that provide that kind of accountability and that kind of change. So this was probably the biggest tax on the civil justice system that I've been a part of, for sure. But it demonstrated to me that it didn't break the system. The system works. It's slow. Unfortunately, with a case like this, it's very slow, but it's a necessary process. And other than trying to get it done quicker, it's a good statement that civil justice matters and the system does work.
That's fantastic. Switching gears to something more US based, you're currently at the center of a very large litigation against Meta in New Mexico, and there was a landmark verdict, $375 million earlier this year. And you recently delivered an opening statement about that seek to label Meta's lack of child safety protections as a quote unquote public nuisance. And then, how do you adapt this legal theory, which we usually associate with environmental pollution? And this is actually close to my heart because I used to work in the environmental pollution space many, many years ago. So I understand actually how the EPA looks at or used to look at the public nuisance theories. But how do you apply that novel theory or that theory in this novel manner to something that is more abstract, such as social media and the harm?
Yeah, no, it's a great question. So in that case, when you represent a state attorney general, one of the roles of that attorney general is to be, they call it the parents patriot, but to basically be the protector of the public welfare. And in a case like social media, just like in opioids, it's the same legal theory. We first used the legal theory actually in lead paint. And the common denominator between those three litigations in bringing a public nuisance claim is the pervasiveness of the injury, right? There's no boundary when there's lead poisoning. It doesn't stop at a house. It covers a community. When you have too many pills in a community, too many narcotic pills or opioid pills in a community, it doesn't stop at a drugstore. It's pervasive. It's ubiquitous. Social media is ubiquitous. There are 3.5 billion users of Instagram. There are 3.5 billion users of Facebook. It is so pervasive that the harms that are caused by the platforms don't have boundaries. And sadly, those boundaries allow children to be in neighborhoods that you would never let your child walk into otherwise, right? So the ubiquitousness of the platforms, the lack of controls and protections for children on these platforms allows for there to be this boundless access of children to potential predators, to inappropriate materials. And then the way the algorithms are sort of designed and the way the features are designed around these platforms, they're designed in a way to engage and grow that participation, not protect. So our theories are premised on a very basic idea that when you injure, and you injure broadly, you injure in a way that is a public problem, not an individual problem, you need to be held accountable under a public nuisance theory. And what public nuisance does that's different from other theories, it doesn't just give you compensation. In fact, it's not called a damage. It's a cost. Public nuisance allows, at the end of the day, the prevailing party to require the wrongful actor to pay for the cleanup. It's actually dedicated resources towards making the problem better or solve the problem, not just to pay some number for the costs of what or damages like medical records or medical bills or whatever. So public nuisance is very helpful in identifying broad problems that require cleaning up. And social media is probably one of the greatest examples of something that needs very serious cleanup, especially as it relates to children and those under 18.
Fascinating. So is it the social media equivalent of like a Superfund site in the EPA, where you pay for the cleanup? Is it?
Yes and no. Super funds are so complicated, and that law is so unique that I wouldn't even begin to hold myself out as an expert in it. But the concept is there. That is, you make a mess, you got to clean it up, right? That's public nuisance in a nutshell. You make the mess, you're responsible to clean it up. And we're going to show you what the mess is that you made, and we're going to tell you what we think the best ways to clean it up are. And by the way, the price tag for that cleanup is this. And so we are determined to hold, not just in New Mexico, but throughout the country and ultimately the world. You're seeing now in Australia and in the UK, restrictions where you can't be on social media if you're under 16. Those are the types of changes, quite honestly, that companies like Meta are more worried about than getting a $375 million verdict like we did. They can pay $375 million. They can make that money in a month. What they can't do, and without feeling a very significant consequence, is protect children in a way that causes them, that allows them to continue to do business the way they're doing it. They have to change the way they do business, especially as it relates to children. And so these changes, these restrictions, this age verification, this process of cleaning up the mess that they create is very, very costly to them in terms of advertising dollars, but it's essential to protect our children.
Makes a lot of sense. And so talking about, accountability beyond the financial penalties, even beyond the penalties associated with the cleanup, I understand that you're seeking to fundamentally restructure how Facebook and Instagram and other Meta properties essentially operate. Can you talk a little bit about what you're aiming to do there?
Yeah, so we had two phases, and our first phase was under an Unfair Practices Act. And we got the jury to agree that Meta in New Mexico committed 75,000 violations of misleading statements. In doing that, we also got a finding that their conduct was unconscionable, meaning their conduct was so bad that it warrants additional scrutiny. So in the second phase, which was tried just to the judge, what we tried was this prayer for injunctive relief. And that type of injunctive relief was insisting that Meta verify the age of a child who gets online. Just like a person going into a liquor store who's going to buy a 6-pack of beer has to show an ID. A child that's going to go onto a platform and be exposed to every neighborhood in the world on a phone needs to verify in a meaningful way that they're of an age that's an appropriate person to be in those neighborhoods. It's not a lot to ask. It's a very simple thing, but it's incredibly costly to the advertising dollars, to their growth and engagement. But it's for the protection of children. So what comes first? Child safety, profits. Our whole case was premised on the idea that profits cannot be above safety, especially child safety. So we're looking for things like age verification. We're looking for things like control over algorithms. We're looking for things like making sure that adults who are unknown to a child don't have access to that child online. There's a type of contact and communication that's allowed to go on right now on platforms that allows for people, and some of whom are not well-intentioned. Some of them are perpetrators of the worst types of crimes. Right now, those platforms allow for them to find children. They allow for them to find people that they know are underage, and they allow for contacts and sometimes meetups that result in some very, very awful things. So the most important relief that we're still waiting to hear from our judge about whether or not we're successful, the most important relief that we think comes out of this litigation is that component of civil litigation that I referenced earlier, which is the change part. You can get the compensation, you can get the answers, you can get the accountability. We've gotten all of those. We need the change. The change is what we need now. And the change is going to come from making these companies do things that cost them a lot of money in effect, but they're really design changes now to make sure the kids are safe. There's a lot of good in social media. Nobody's saying that these platforms are bad. Nobody's saying that they're not useful. We all have to use them at some point in some way. But there's no reason to have it be such that that these companies don't protect those that are under 18. And those are, quite frankly, that are under 13, who they know are on their platforms and are getting exposed to things that they shouldn't be exposed to.
That makes a lot of sense. I mean, Don, your analogy about the neighborhoods is so visual and visceral because, as a parent of a young child myself, I can feel that, right? Because, I know which neighborhoods to not let him go into, but, on the phone, you're sort of there on their own and they're exploring all these neighborhoods that are much bigger in size and scale and spectrum of people than you would encounter in the physical world. So
right. And that's the most horrifying part. And so, the social media platforms defend their case in some part by saying, it's really up to the parents. It's up to the parents to watch their kids. And while you, as a parent, you have to do your best, right? The parent is fighting an algorithm that our most well-paid experts have a very difficult explaining how this material gets in front of your child so quickly, right? So the parents are fighting up against algorithms. They're fighting up against design features that are caused to addict, to draw kids in who are the most vulnerable to addiction, and draw them in and hold them in for longer periods of time. Parents are up against access to communities that they don't even know exist. So parents have a role, but relative to the role that these companies that are designing these platforms, it is minuscule. And keeping our kids out of those neighborhoods is a joint responsibility, but the largest share of that responsibility belongs to the platforms that design the platforms in a way such that kids are immediately transported into the worst imaginable neighborhoods.
Makes a lot of sense. Switching gears to something that goes back to your family's medical roots. So you've gone up against C.R. Bard and Johnson & Johnson's Ethicon unit multiple times over mesh litigation. So pelvic mesh, hernia mesh, and then physio mesh.
I don't like me there.
Can you elaborate on some of the work that you've done there, how those matters, sort of progressed, and what are some of the outcomes that you've been able to drive?
So the initial litigation began back in 2007. There's a company called C.R. Bard that had a division called Davol. Now, Davol was actually 1 mile from the house that I grew up in Rhode Island. Very strange fact. But the litigation started to develop because some of their meshes were splintering and puncturing intestines and other internal organs and causing such a problem that they were recalled. So the Davol litigation resulted in a mass tort filing, ultimately an MDL. And when it happened in my backyard in Rhode Island, where I grew up, a mile from my house, I had to be a part of it. And our firm, with the resources that we had, having done now the asbestos litigation, which is the biggest and the first mass tort litigation ever, we had already started the 9/11 litigation. We're deeply involved in other medical mass torts. Having this be a Rhode Island issue made it compelling. And us having a Providence office it made it compelling that we needed to be a part of it. So we petitioned for an MDL. It got assigned to the district in Rhode Island, the first MDL ever in the state of Rhode Island. And then there was a state court litigation also in Rhode Island. So between the two courthouses, less than a mile apart, we had every case in the country of a barred defective mesh in the state of Rhode Island. And I was lead counsel in both litigations. We had both judges sit together in one courtroom, the federal court and the state court. It was really sort of a cutting edge approach to bringing state court and federal court litigations together. And we got into the medicine, we got into the science. And ironically, one of my brothers is a hernia surgeon and actually consulted with Bard throughout the course of his career. So I even had a brother who was a consultant to one of the defendants, to Dave and to Bard. But in the end, it was a defective product. People got seriously hurt, some died, and we needed to bring some justice to it. So over the course of time, we became sort of specialists in mesh litigation, in litigations that involved synthetic polypropylene and PET materials in the body that could wreak havoc. And that litigation lasted for 3 or 4, maybe 5 years. And at the same time, similar materials, but used in the pelvic floor, started to emerge as having similar complications, but in this instance with pelvic mesh, specific to women. And women that were getting meshes for urinary incontinence or for prolapse were having mesh put in. And instead of having the mesh erode into intestines, we're talking about mesh now eroding into the vaginal wall. We're talking about mesh eroding into the bladder. Very, very serious complications, unfortunately, very specific to women. And that litigation became ginormous. That MDL got filed in West Virginia, and we were very prominent in the litigation. There were 5 different manufacturers, including Johnson & Johnson and Bard, but also AMS and Boston Scientific and some others. But the long and short of it is over 40,000 claims were brought in that litigation. Same general science, same medicine, different area of the body, different complications, different long-term injuries to women. But our 5 years of leadership and work in the hernia mesh litigation prior really put us in a position to bring a lot of knowledge, a lot of background, a lot of documents, a lot of experts to the table very quickly to help bring that very important pelvic mesh litigation ultimately to a conclusion. And then strangely, as that started to die down, hernia mesh started to come back with other companies. So now we've got hernia meshes with various manufacturers that are now being pursued, including Bard, a company called Covidian, and we had some other cases with some similar products called Atrium. So it evolved over time. Rhode Island was an epicenter initially, and the science built on itself. But it's something that basically has been going on now for almost 19 years.
Wow.
And still going on today. We have trials to this day against Covidian in hernia mesh.
That's a long time scale indeed. If you take a step back now, Don, and obviously you've been involved, and you just gave me and the audience just a very high level overview of these massive matters of significant import to sort of the general population of the United States, at least, and even beyond. If you take a step back and sort of look at those 4 decades that you've been in practice, right? What are some themes that emerge in terms of how defendants generally tend to behave? Obviously, these are different industries, they're different companies, they're even different entities, foreign countries, things like that. What are some patterns that you've seen, similarities and differences? How do you sort of work through them? What's your sort of secret sauce, to the extent you can share?
It's a great question. I think that I want to believe that the civil justice system over time causes companies to behave better, right? Even if it's out of a fear of being brought to the table, that over time, behavior is learned to do better, and people want to ultimately do better. It doesn't always appear to be true. If you look at the social media litigation, for example, there's a lot of similarity between how the social media industry handles its issues and the way the tobacco industry handled it for 50 years before that litigation came to an end. So I'd say the similarities are that companies are driven by profit. Profit tends to cause people to make choices, companies to make choices. Oftentimes, those choices put safety secondary. So that's what, unfortunately, is a tale told over time that doesn't seem to ever completely die. It's what asbestos was about. It's what tobacco is about. It's what the opioid litigation is about. And it's certainly what the social media litigation is about. Putting profits over safety exists. The differences in trying those cases is technological, I think. I think technology has changed so much of it. In our tobacco litigation, asbestos litigation, when we did discovery, we literally went to warehouses all over the country and went through boxes and we looked for paper. And if that paper existed, we got lucky. If it didn't exist, we got lucky. I went into a warehouse once when I was a young lawyer at Motley, and it was in Knoxville, Tennessee. I went into this factory. I opened one of the boxes that was in their storage room, and a massive spider. I don't know if it was a tarantula or this, a massive spider emerged from the box, and I shut the box. Now, that box could have had the most important data in the world in it. It may not have, but I wasn't going to find out. That thing scared the heck out of me, and there's no chance I was going back in that box. Didn't know if there was a snake in the next box. I had no idea. Today, those documents exist, but they're electronic. Even the old documents are now somehow available electronically. And the technology is so wild these days where we can go through millions and millions and millions of pages of documents and gather so much information to learn how to learn the documents, right? That the machinery and the AI now is allowing us to learn how to learn about what's in those materials and where to look next for them. So our ability to hold companies more accountable today isn't because companies are behaving different necessarily. It's because we're able to call them out using their own documents in a way that's much more advanced, much more sophisticated, and if done right, much more effective. So we always had that one document that we had to keep photocopying and make sure that we never lost it. And I had so many different generations of photocopy that it became a blurry document, but we would wave that document in front of that jury as much as we could in an asbestos case. Today, we're able to produce emails and comments between people that are made seemingly privately at the time between two people that are now very much public and very much show a culture within a company that we can then use AI and other technologies to really see how pervasive that culture is and really present the case in a different way. So I think we'll always have in our system companies that are always looking to make more money and be bigger and be better. I think companies do care. I'm not saying that all companies don't care about public health and public safety, but they're going to push the profit over safety limits, and sometimes they push it to a breaking point. I think now with our technologies and our sophistication and our court system's ability, as I said before, the system works, right? And as technology evolves, courts have been able to really bring in this technology as part of the process now. The discovery process involves so much technology today. The courts have to be sophisticated in the technology. But that accountability and that technology and that sort of approach to things, I think makes it a whole different game for us today than it was when I started about how to tell the story and how to simplify things.
Thanks for sharing that, Don. You mentioned something very interesting there in your sort of overview of how you use technology. And you said that you use technology to learn how to learn, almost like a metacognition. Can you expand on that? What you mean by that a little bit?
Yeah, I mean, when first started in the hernia litigation, the 2007, 2008 time we started to do discovery, there were companies that were out there that were trying to push this idea that their search engines could learn hot phrases, right? It can scan the documents, it can put some words together, and if you like those words, you go look for those words somewhere else. And it was a really crude beginning to intelligent technology that would do some of the learning and digging for you. Today with AI, that's become a necessity. It's not even like a useful tool, it's a necessity. In the opioid litigation, we had tens of millions of documents across multiple manufacturers. Nobody could read that. We couldn't hire enough people to read all of those documents and then give us coding on what each of those documents mean and where it fits in the story. With AI, we can put those documents into a system, and the AI can start to learn the stories and repeat back what it thinks the story is. It always will require skill. It'll always require a lawyer's eye. It'll always require that sort of that unknown art and science that lawyers bring to the process. But when the lawyer puts back into that AI system its sort of view of what you're saying these documents mean and what I need you to go understand, whether these ideas actually develop into a certain pathway, whether they result in a certain outcome, whether they interact with other knowledge that we have about this company or about these injuries. When you bring your information into AI and retrain it to learn what you care about, it goes and finds some more. And then it comes back and it trains you. Well, this is what we're seeing in the documents. So then you have this sort of interaction with AI where you're really saying, okay, what else can we figure out here? What else can you help me understand? This is where I think this is going. Now, some of that's also shaped not just by our own skill and science, it's shaped by the law. You asked me about public nuisance. If I need to know, what a company's doing in order to protect or not protect children, or how much it knows about the impact of its design on a community, I now can bring in ideas about what the law is, what the law requires, and say, help me learn, and let's learn together what these documents say about what this cause of action is. And it becomes this back and forth. So it's a learning to learn and to teach, and it's constant, right? Lazy lawyers will rely on it and just say, this is what the answer is. And that's where people get in trouble. People get in trouble using AI in a way to sort of make their jobs easier or faster. But what AI really offers, what makes it a totally different game today, is this idea that you can actually have a process of learning and training technology to help you get towards answers that are in the materials that you have, but you have no other way to collect without using the benefits and the speed of what we now call artificial intelligence.
Fascinating. I really appreciate that answer, because to me it sounds like there's two attributes that you're really leveraging right now, and there may be more, but one is obviously the speed. As you mentioned, it's just much easier for AI to go through all of those banker boxes and so forth, and not worry about spiders and snakes and so forth. But also using certainly the more advanced AI models as almost like an intellectual sparring partner. It's like, hey, is that a fair assessment? Or
Absolutely. Not only a fair assessment, it's critically important. In the end, there's a rule 11 in our practice. If you do something that's without merit, you will be sanctioned and you can lose your license, right? In the end, you have to sign off as a lawyer that what I'm doing is intellectually honest, it's consistent with the law, it is not misrepresenting the facts to the court or the jury. You still have to sign off, right? So AI is a process of really interacting with intelligence that is fast, it's efficient, incredibly effective, can find connections that you normally couldn't find unless you were reading everything at the exact same time. So it's a very efficient tool, but it still has to come back to your lawyering. It still has to come back to your message. It still has to come back to your voice. When you're hired by clients, even if it's thousands of clients at a time, you're hired to give voice. That's my job. My job is to give voice to people. And to give that voice, I've got to have interactive banter, right? I've got to go back to my office and at the water cooler say, what do you think about this problem? With AI, I get to do that in a very sophisticated way. I get to do that in a very large scale way with large amounts of material. And the AI is the water cooler conversation. It's just with something incredibly sophisticated, right? It is, what do you think about this idea? And it spits it back to you. Now, when it gives it back to you, you've got to verify it. You've got to go through all the steps of making sure those documents say what they say and that they mean what they mean. And many times you'll see that it's a misinterpretation of what is actually in the document. And so you got to back up and try again. But in the end, you're responsible for it as a lawyer. And if you're going to give that voice, you better make sure it's right. But it's a powerful voice. It's a powerful banter. And it's a critical part of mass tort practice now. It's probably a critical part of single event motor vehicle accidents. But I can tell you right now, you can't do 10,000 plaintiffs and not have the benefit of that kind of resource.
It makes so much sense, especially at the scales at which you and your firm operate. So that's fantastic. Well, Don, this has been a fantastic conversation. Just a couple of quick questions to sort of wrap this up here. One is, you've obviously had this wonderful and rich and fulfilling career that has driven so much significance for so many over the past 4 decades. You've also taught mass torts as an adjunct professor. You alluded to the course that you at the beginning of our conversation here. If I am an early career attorney, maybe in law school, maybe just graduated from law school, and I have two sort of things that I'm concerned about. One is, hey, how do I get into the space of MDLs and mass torts and so forth? That's one. So that's on the practice side. And then two, I don't have the knowledge and the history that Don Migliori has, but I want to use AI. How do I leverage AI in my early career stage, sort of from a process perspective? And then obviously, how do I connect my interest in MDLs to my usage of AI? I know it's a sort of multifaceted question, but I wanted to ask it of you.
No, it's a great question. It's involved. So on the issue of a new student coming out of school, when I first started, asbestos was the only mass tort. So there weren't many firms doing it. In fact, Ness Motley at the time was sort of known as the national firm because it was one of the first, if not the very first firm to take on the asbestos industry. So I got lucky because they happened to have an office in Rhode Island. I went to Brown. Their office was in Providence. I was aware of them. But other than being aware of them and knowing the people that were involved in the firm, I didn't have the ability to say, I want to do mass torts. It just kind of happened. And I got very lucky to get thrown into it. Today, there are mass tort firms in every state. And I think a lot of law schools, just like Roger Williams did, actually will teach some component of multi-district litigation and mass torts because it's become, since I started, it's become a much more developed area of law. So I would tell the young student in law school to look for the types of firms and opportunities and clerkships to work with a firm that does more than single event type litigation, but really does litigation that's sort of premised on the idea of multi-district litigation and class actions even. So there are resources there. Certainly reach out. You can reach out to me. And if there's an interest in a certain state, there's not a state that we haven't practiced in. And so if there's a state where you have a question about who does this kind of work and what kind of work, it's easy enough to find those types of law firms, and they all offer some clerks. So just be resourceful and go out there. It's fun. And it's again, meaningful. It's impactful. It's rewarding. It's also, there's no work-life balance. I have to warn any law student, if your goal is to have work-life balance and to meet your friends at 5:30 for drinks every day, this isn't the practice for you. It's a 90-hour-a-week practice, easy. And I just finished 5 months of trial in Santa Fe where I saw my family 3 weekends. So it's intense, but if you believe in it, your family believes in it too. So that's the question about law students and how they might get themselves involved. On the question of AI and how do you get there, I also think that schools now, there's not an industry that is not figuring out how AI makes its industry better. Whether it's, I'm on a board of MUSC, the hospitals and the medical universities are all trying to figure out how AI makes taking care of patients and teaching medical students better. Law schools are the same. There are resources for learning AI early. But I can tell you that when I have an issue about AI, I tend to go to the younger lawyers because they are much more focused on the technology because they've been the guinea pigs. Even in the social media litigation, the reality is having a 60-year-old man like me trying a social media case requires me talking to 22-year-olds who've been the guinea pigs for the past 10 years about how these platforms work. So I think young lawyers have a natural sort of awareness and sensitivity to how to use AI. I know they're using it to build their resumes because when we get resumes for new jobs, AI is creating a lot of those resumes. Letters of recommendation are being written by AI. So the Claudes and the OpenAI and all of those things are out there. How you turn it into a useful tool in your practice, we're all still learning that, right? The law field is a little more conservative than other industries in AI. because of the risk of getting it wrong, right? AI is still developing, especially when it comes to case law and what's good law today and what's not good law. And so the lawyers that have gotten the most trouble have been the ones that have not done that follow-up, not done that check. They've used it as a way of making their lives easier, not as a way of helping them do better. And so what I would say is law is a little slower to completely absorb it because of the concern of getting it wrong. But I think right now we're almost a full stride in law with AI. I think the younger lawyers get it just more intuitively because of the way they've grown up around technology, and the resources are out there. But go to things like the American Association of Justice conferences as a young lawyer. Go to your state trial lawyer conferences. These vendors are there to show you what they've got. And lawyers are giving talks. They're giving their presentations at these conferences about how they've brought AI into their practice. So getting back to this idea of community, the law field is a community, and there are a lot of people out there that are trying to do really good stuff. And you can learn a lot from every aspect of the bar about how to leverage important things like AI. So just get out there, go to the conferences, go to the, talk to people, pick up the phone, and get yourself exposed, right? As a young lawyer, the worst thing you can say is, I don't have time for it. You've got at that stage, you've got nothing but time to learn your practice. And getting exposure, even if ultimately you choose to do different things, getting exposure to every aspect that you can is critically important. So I think the technology is going to pass my learning curve in the near future.
Thank you so much for sharing that. I'm sure our that section of our audience will appreciate that, Don. So, final question for you. Is there a question that I should have asked you, but I didn't?
That's great. I look at this very conceptually, right? Like I truly believe in the civil justice system. And so I guess if you were to ask any sort of point blank question of me that maybe I didn't get hit between the eyes with, it would be, why do you do it? Why do you spend so much time? What are the consequences of doing this? And what makes me think of that is one of my last answers was, I have 5 children, and they are my world. My family is my world. And I can tell you that they missed a lot of me over time because of this job. And when they were young, it was hard to explain to them why I would do it because they didn't really understand. They just wanted me out there. In fact, I just left my daughter's play to be on this podcast. But when I was young, I missed a lot of plays. I missed a lot of sports. I missed a lot of show and tells. And for a child, it's really hard to explain. But now that my children are getting older and they're starting to be a part of societies and communities and start to have strong feelings about socio-political issues, and then they look back and they say, well, Dad worked on the opioid litigation. Dad worked on the 9/11 litigation. My kids are coming to me. They're proud, right? So if you're going to do this, I encourage you to do it. I encourage you to talk and get out there. But no, it's a hard life. When my kids now tell me how proud they are and how much they respect what I do, it's sort of that answer that I've been waiting for a long time. Is it worth it? Was it worth it to spend that much time away from what you care about so much to do impactful litigation? And my kids are telling me now that the answer is yes. So the short answer to why did you do it? I did it because I think it mattered. And when my kids tell me that they think it matters, that's the only ratification I need. And it's a great feeling. So I've been very fortunate.
That's amazing. Thank you that's very touching, and your kids have every right to be as proud of you as they are. So thank you for sharing that. Yeah, well, thank you so much, Don. This was a fulfilling, enriching, illuminating conversation for me, and I'm sure it'll be the same for our audience as well. So thank you so much again for your time, and all the best for all. And I hope you continue to drive the impact that you've done over the years as well.
I appreciate it. I have a 10-year-old daughter, so I'll be doing this for a while.
Excellent. All right, take care, Don.
Pleasure. Thanks so much.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.